welcome to Legally Speaking with me, Tarun Nangia. Today, we're going to discuss a really interesting subject. Can a certain business entity use the brand identity of a competitor in the Google AdWords? And then what happens? I mean, will the traffic that was intended for one company will then go to another company? Today, we're going to discuss the case that involves two companies, Booking.com and MakeMyTrip.com, two of India's leading companies in the travel booking space. And also, this judgment has been delivered by Justice Vibhu Bhakru and Justice Amit Mahajan. A really important judgment that will have impact on many such cases across sectors because it involves the use of Google AdWords to drive traffic to their websites. I will not reveal further details. That will be for my panelists to do. I want to welcome Malak Bhatt. He's founding partner of NM Law Chambers, and Manmeet Singh. He's a senior partner with Saraf and Partners. Good to see both of you, and looking forward to hearing some interesting insights on this judgment by Justice Vibhu Bhakru and Justice Mahajan. At the outset, let me request Malak Bhatt that in the next 3-4 minutes, could you give us an introduction into this judgment, and then we will move and discuss the specifics. Over to you, Mr. Bhatt.
Sure, sure. And thanks, Tarun, for having us over here. It's always a delight. Let's just break out the judgment in very simple bare bones as to what led to this judgment being passed. So, as you rightly pointed out, Google runs what is called a ads program. It's an AdWords program where you can sponsor and on the domain select certain keywords where if the person who's using the customer who's using Google, the moment you type in the keyword, if you're part of the sponsorship program where you've already paid subscription for using that keyword, your web page will automatically appear on the first or the second page basis of subscription with a subscript called AD, an ad, or would generally appear in the first few searches, making it a more searchable domain for customers who are using that. Now, the interesting question that came up before the High Court here was that if the keyword is similar to or the keyword by itself is a trademark which belongs to one company, can another company use it as part of its keywords to actually claim that they will be able to use the Google domain by that? So the case that came before the High Court was in this flavor where Make My Trip, who claims that they have the trademark for using the word Make My Trip together in that connotation, or MMT in short, has the trademark or as a registered trademark for these particular the words as trademark itself. So they are trade dresses. The case was that MMT had filed, Make My Trip had filed a suit before the Delhi High Court against Booking.com and against Google, both together, where it said that, look, Booking.com is using these keywords as a keyword for their own Google search under the the Google AdWords program. And by the fact that they're using my keyword, a keyword which resembles my trademark, is an infringement of my trademark because A, they're in the similar line of business. So what happens is that the moment a customer searches Make My Trip on Google, while the first link or the second link may be Make My Trip itself, the immediate next link or probably the link even before that as part of the sponsorship program would be of Booking.com. So they claim that this is a clear violation under Section 29 of the Trademark Act, a violation of my trademark, which is a registered trademark in India. Now, the single judge actually granted the injunction and said, yes, prima facie, it does appear that this is a violation because the wording is similar. B, the very fact that you're using keywords of a competitor to come to a search program which is usable on the Google platform is in quote unquote use by Google and by Booking.com of the violated trademark. And the injunction was granted to that effect. Now, interestingly, it is Google who came up in appeal. Ideally, one would have expected Booking.com to be the sufferer and coming up. Google came up and said that, look, I could not have been using this in the first place because I am the search engine which is providing this platform of being the sponsor, the SERP, the sponsored advert program. Number two, in any case, this cannot be a violation of the trademark because these are keywords which are used for the purpose of coming to specific search hits. Interestingly, the division bench's judgment, which we are discussing today, sets aside the single judge's judgment and says three very beautiful things. I think it's a judgment where logic strikes at the core of law is what one would say. That a customer who is friendly, who knows how to use the Google database, is searching and going on the Google search engine and putting in Make My Trip, knows there is a difference between Make My Trip and Booking.com. And since the businesses are similar, if there is no intention to deceive, or if there is no confusion which is likely or is trying to be created, the mere fact that keywords are being used which are similar to, or the identical trademark word which is being claimed by Make My Trip, cannot in any manner constitute a infringement of that trademark. And on that front, the single judge's bench judgment was set aside, and they've cleared out the air that the use of keywords on the Google Ads program, which may resemble or which may strike balance or strike similarity to a trademark belonging to the other company, cannot per se by itself amount to an infringement of the trademark.
Okay, point well taken. Thanks you for explaining in the introduction details about the judgment. I'll go to Advocate Manmeet Singh, Senior Partner, Saraf and Partners, for his opening comment on this.
So thanks for having me on your show. So as Malak said, the division bench of High Court analyzed the section of the provisions of Trademark Act threadbare and looked at various contentions which were raised in the context of Section 29. And it followed its earlier decision in the case of Google versus DRS Logistics, which had been decided shortly prior to this decision, and held that where there is no intention to deceive and there's no deception caused, in such a case, merely using a trademark as a keyword for producing an ad would not amount to a violation of the Trademarks Act. Now, one must understand that a lot of these digital service providers rely on advertising services as a key source of revenue to offer their services at a virtually very little cost or no cost. Google today is not charging for its search engine. So I think one also has to be very cognizant of the fact that a significant public good is being provided through these services, and such an injunction therefore must not be lightly granted, as was done in this case. And after analyzing the various provisions of Section 29 which were alleged to be in violation, the court, after having carefully considered all arguments, concluded that there was no violation made out. Now, one can argue whether the Trademarks Act is in sync with the digital world and what it should be. But the way it is right now, the court concluded that in the facts of the case, there was no deception, there was no intent to mislead the consumer. The ads which were put out were clearly marked as ads, and the consumer would be able to make a distinction between MMT as a brand and Booking.com as a brand, and therefore concluded that prima facie there was no ground for an injunction to have been granted in the facts of the case, and set aside the single judge's order.
Okay. Point well taken. I'll go to Malak Bhatt, founding partner, NM Law Chambers. Mr. Bhatt, two things here. Did the court find that Booking.com was in the wrong for using the competitors' keyword, so to speak, to drive traffic to its own website? Do you think this is the case of an attempt to garner traffic to its own website using this kind of means? And is this a gray area? Because keywords are something that you don't disclose to the competitor. Whenever you put a certain keyword, that it's an activity you do, it's a hidden activity, it's not a public activity in that sense. You do it on your computer. Could you explain this to the audience?
Right. So, in fact, the court held to the contrary. The court said that the mere fact that Booking.com uses a keyword in the form of Make My Trip or MMT does not by itself constitute a violation of Make My Trip's trademark. And this is foundationally on three fronts if you look at it. Number one, this is the court's recognition of the technological developments that are happening in the country. It is not a hyper-technical read of the Trademarks Act to say that, look, there is a specific word. That word may be in a specific trademark format or a trade dress format or a word format. The very and one point used to happen that a lot of times just the use of the word would be constituted as a trademark violation, because that's the entire essence of a trademark, that you have your entire reputation hinges on the fact that that word belongs to you. But we've lately seen a lot of cases where, especially in the Google AdWords program, the generic words which are used in the company's name are also becoming the keywords for that particular company. Now, does that mean that that a competitor or someone who's doing a similar business loses the right to use such words completely? And that's the court's answer saying no. The strike of this, in fact, is more so because, and that comes out from various paragraphs of the judgment, that this is not a fly by night operator who's trying to make his reputation at par with Make My Trip. You have a company like Booking.com, which is equally prominent in the market, which is equally a worthy competitor. So, someone who is going to go and use the word Make My Trip, or let's say for that matter, even My Trip on Google, knows the difference between Make My Trip and Booking.com. The question, in fact, which they've left gray, and that's exactly what Manmeet pointed out, that prima facie it may not be a violation till the time you can not allege deceit or confusion. And to see whether that deceit or confusion is there is, I think, something which the judgment has very beautifully left out. Because let's take an example here, that there is a event planning company, or a company which does itinerary. We've seen a lot of these companies today do bespoke itineraries for people, and they have a trade name which is similar to Make My Trip, and they're trying to couch that to say, okay, we are somewhere related to Make My Trip, or we are part of the Make My Trip program. That may still count within the counters of deceit. But what the judgment categorically says is that the mere fact of use of that word by itself is not going to be enough for you to prove a violation of infringement, which I think is very, very progressive in terms of the way we are seeing technology develop.
Thanks for that input. I'll go to Manmeet Singh. See, this kind of case will have much wider ramifications across industries, because sometimes some brands become, in a sense, generic names. In the olden days, photocopy and Xerox were taken in the same breath in the Indian market. In some markets, certain products have a certain dominance. Be that as it may, could you reflect on the impact of such a judgment? And does this judgment, in a sense, limit now all companies from using their competitors' keywords? Is it by implication that this will happen? Can you explain to the larger audience?
I think the judgment is in the facts of the case. And therefore, each case will have to be looked at separately to see whether there is an attempt at deception, whether there is an attempt to mislead the consumer. But but what the judgment holds is, per se, merely because somebody is using a keyword which happens to be the registered trademark of a competitor, it would not be a per se violation. And that is the important thing, because what is the keyword being used as? It is only being used as a cue or a prompt for the algorithm to produce a relevant advertisement, which is marked out as an advertisement. It appears in a separate section of the search page. And therefore, to the consumer who's using the web page, it is very clear that the advertisement is separate from what the consumer has searched for, which will also show up. It is not as if that the search which the consumer was intended for is pushed lower down. There's just an advertisement which shows at the top. So the first organic search result would certainly be that of the company which owns the trademark. So, given that, I think this is a judgment which certainly impacts all digital service providers, be it not just search engines, but also all social media platforms which rely on advertisements. And I'm sure, or at least I expect this judgment to be carried up in appeal, because Make My Trip would certainly would want to see what the position of the Supreme Court would be, given that there are interesting questions of law which get raised here. But my own reading of the judgment of division bench is that, at least in my reading, it appears to have correctly interpreted the law as it stands today. And therefore, as far as the big tech companies are concerned, or social media companies are concerned, I think it lifts the cloud around advertising as a viable business, as a viable source of revenue in India.
Okay, point well taken. I'll go to Advocate Malak Bhatt from NM Law Chambers. Mr. Bhatt, one thing I would like to know from you. For example, a hotel company puts in its keyword the brand name of another hotel company, which is its competitor, so as to drive the traffic of that hotel group to its own company. Now, would that by implication be seen as a violation in the light of this judgment, or that would have to be fought separately in the courts of law?
So, as again, if you go back to the language of the judgment, you will have to see the standing of to actually deceive their traffic to take them from that particular competitor's brand to yours. Because ultimately, what you are analyzing is that the mere fact that I've used that keyword does not necessarily mean that I have does that amount to a violation of the trademark? Less than what may happen is if every case is taken at the threshold and said the moment you use the keyword, it's not allowed, Google cannot allow someone else to use that particular keyword. You'll end up in a situation where, if, say, let's take your example, I'll you search for a brand name X, and if X is a trademark belonging to one particular hotel brand, you may end up in a situation where the Google search program will not be able to give more than one result, because everything else will be a violation, or you'll end up with only those searches which that company is allowing them to use. The idea today is to also benefit the consumer who is wanting to look at, say, X option, but at the same time his data search should not be restricted to just that one particular uh, company or institution which is owning that trademark. At the same time, you counterbalance the right that if someone is using that only to ensure that the trademark is used for the purpose of shifting traffic, then obviously that's a stage which the court will have to then analyze. But interestingly, what this judgment also talks about is, the question raised was, what happens if there are similar industries, or what there are different industries? The court said that, look, this ultimately is a rebuttable presumption. The presumption will obviously run against the person who has alleged the violation. But at the same time, if you can prima facie show that my intention was not to divert, because let's just take a very straight example. You talk about Taj, but at the same time you talk about Oberoi, where Oberoi is using, say, Taj as a name. You know that it's a equally qualified competitor who otherwise is anyway being looked at by the customer. But if you have Taj as compared to SP Taj, which is like a 1 3 star hotel somewhere in the suburbs of the country, you know for a fact that the idea is to try and put yourself out there, trying to show you as part of the Taj group. A very straight example. Then obviously the contours of deceit, the contours of trying to create a confusion grow up. But these are all presumptions the court says have to be tested. And the fact that there is just a simple use of that word does not mean that you strike a yes, saying yes, the box of infringement is ticked out, and therefore I will grant an injunction per se. And in fact, just to add to this, what happens is, in most litigations, Google gets dragged, because every time the Google Ads program or the search engines program is used, they say that the Google or the search engine is the person who's actually the beneficiary, because they're allowed to use and make revenue out of it. At least for them, it's a big respite to say that, look, I don't have to go and prove violation at every point of time.
Mr. Bhatt gave a very nuanced argument. 3 points that I could cull out from that argument. One was, if Taj and Oberoi and one brand does this, then both are equally qualified and large hotel brands. But if some small 3 star hotel, which is a Taj, does it to drive traffic to its website, then it will be construed otherwise. Be that as it may, if this is the argument, then Manmeet Singh, could you just share with us? Though precedent is set by such judgments, again, courts will have to go case by case basis in such cases, because this would mean that no new company can come up. Let me share an example. Suppose a new competitive product is out in the market and it wants traffic to itself in order to show to the people that there is a better new product in the market, and it uses the competitors' keywords, then it is an attempt to show the product, rather than, by implication, it's a different brand. Even if people come, they know it's a different brand. Could you explain that no precedent is set, or is there a precedent with this judgment?
I think this judgment only settles the principle that using a registered trademark as a keyword for running an online ad would not be a per se violation of the, or per se infringement, or the infringement of the trademark. It does not go beyond that, and each judgment will have to be seen whether each matter will have to be seen whether the intention is to cause any sort of deception, cause the consumer to be misled, or are you, as Malak gave that example, that are you similarly placed, not similarly placed, what is the intent, and therefore those things, each matter will need to be decided on the facts. But what it does is it just sets out that first principle that it would not, so not every time a keyword is used would an injunction need to be granted.
Okay, okay. A point very well taken. I'll take this to Malak. But see, in an emerging economy where there are new startups in every space, be it the hotel space, be it the travel space, every second day. Also, Mr. Bhatt, we see that many new startups have deceptively similar names to existing successful startups. These two are market leaders. Make My Trip and Booking.com are market leaders, but I'm talking of new companies with similar names. Do you think that is where the courts will have a challenge?
Absolutely. And in fact, that's the time where if you break out the word, you will see most of, because right now the question before the court was pertaining to the entire name of Make My Trip being used as a keyword. A lot of times you will see that the names A are generic in form or are a culmination of more than two or three words. And typically we've seen trade dress cases in court when they reach are similarity to either some part of the name or the entire name as a whole or some acronym of that particular name. And I think that's where the large part of the court's time is going to be used with interpreting this judgment. And since you raised this, let me just bring this out. One straight example that comes to my mind is, if you see, apart from Make My Trip, there is also a company called Ease My Trip.
Yes.
Now, My Trip by itself is also part of the trademark. Now, if one uses the word My Trip and My Trip appears only as a trademark belonging to, say, let's example X company, and some other company which also has My Trip as part of its name also uses this as a keyword, will that become a challenge? The immediate answer with this judgment at least says no, because the fact that I'm using it cannot be considered to be infringement. The person claiming infringement now has to go a threshold higher than this. So as Manmeet said, the base principle is set. The principle that is set is the mere use cannot be infringement. Person claiming infringement then has to show something more to actually claim that injunction. In fact, this takes you right back to the principle, the primary three focus principles on what a mandatory injunction really entails: prima facie case, balance of convenience, irreparable justice. And I think this judgment, in fact, goes right back to that, saying that these core principles, especially in cases of creating curtailing rights of freedom of profession, freedom of doing trade, have to be counterbalanced much more for the person who's actually claiming an infringement now.
Point well taken. In a new age economy where many brands are being created every day. Manmeet Singh, I would like to ask you that this calls for a lot of long, exhaustive arguments in court in every case, because I see there is a lot of nuance in these arguments. New competitor, intention to deceive, or established brand, so there is no intention to deceive, just to show customers that there is one another competitor also there, but the customer will not be deceived because two brands have distinct identities. Do you think that in this economy where the whole rules of business have changed from traditional print media to now Google today, that this will everything will have to be case by case and no precedent can be set in such matters?
Certainly, Tarun. I think this now becomes a fact-specific inquiry in every matter going forward. And I'm sure there will be a lot of debate in the academic circles around the legal position as well, as to whether the Trademark Act needs some sort of examination to address some of the issues arising out of the digital economy. But for the time being, I think the decision which has been rendered is, in terms, strictly speaking, absolutely, in my view, in my reading, absolutely in consonance with the Trademarks Act. So I see no difficulty as far as the current regime is concerned. But it'll be interesting to see if this judgment is carried to Supreme Court as to what the highest court has to say on this, and whether its view is consistent with what DB has said or whether it chooses to set aside. But there'll be certainly a lot of debate in the academic circles, because you're absolutely right. This will become a case by case analysis. I see a lot of litigation around this issue now, because since there is no absolute principle which has been set, and there is no per se violation now, it's down to the ingenuity of lawyers to show how how cases are different in the facts of the case. No injunction is required to be given.
In fact, in the past few years, we saw many platforms before court. When the court told the platform that take out these comments, and they say, no, these are the users' comments, you can tell the users to take them down. Why should we take them down? We are just a platform. We are providing these services. The user is if he's done something wrong, he should take it down. Do you think platforms are also learning to deal with the system, which is the courts and all? Is it a learning curve for the platforms also? Platforms in this case could be Google, Twitter. These are basic platforms providing these services to consumers.
Yeah, absolutely. I think in this case, perhaps more than Booking.com, it was Google's interest which was getting affected, because it could have had a far-reaching implication on its model as it stands, as regards advertising at least. So therefore, it was Google which carried this matter to appeal and not Booking.com. Yeah, and similarly, I think all social media platforms also would have a similar model. And therefore, yes, this would be an interesting area of law to watch out for them, how the law shapes up and how the policy around this and the debate around this evolves.
Point well taken. Mr. Bhatt, any comment on this?
Yeah, in fact, as very rightly pointed out, see the entire economy with respect to platforms and these e-commerce platforms or social media platforms thrives on the ad system. The entire revenue source is from advertisements. So for Google to actually proactively take up this issue before the court, before Booking.com, who's actually in that strict sense hurt by the order, shows that they are also conscious about the fact that the law regarding violations of IP, especially in the contours of a competitive market, which today is catering to millions of people who are now exposed to the internet, who are exposed to technological advancements, has to then balance their rights for just the rights of a simpliciter case of an infringement. Because till these media platforms came up, if you see the kind of litigation that was taking place before the courts throughout the country with respect to IP litigation was largely regarding tangential or physical form of violations on search engine. And in fact, a very interesting example that was used in this case, and I'll point this out, Mr. Sibal for the respondent had raised an argument for Make My Trip, that the very fact that the word is used on the search engine is actually a labeling of that keyword to the brand of another company. So he had tried to draw an example that, like, I use, say there's a physical form of a trademark which belongs to a particular company, and I use that particular bottle in my company with my company's name. I'm labeling my product with that particular trademark. He says the very fact that a customer keys in a keyword which belongs to or it is a trademark of the other company is in that sense a software oriented labeling. And the court obviously rejected this contention that it's too far fetched, because the very fact that you have a keyword which generically belongs to you cannot be a violation. So these are examples which today will now start seeing more and more in court. And I think it's going to be a very interesting move to see how a lot of these plays out, especially for the platform companies, which will have to shield their own policies more so, because their entire revenue source depends on this.
There's a very interesting arguments today and insights on the show today, and good judgment by Justice Vibhu Bakru and Justice Amit Mahajan. I think this is not the end. There'll be many more matters in these kind of issues that will crop up in companies, especially as I would like to point out, newer companies would also make an attempt to attract traffic, showing that we also exist in the market. The only easiest way is to put in the competitor's keyword. What will happen then? Given the fact that what Mr. Bhatt shared with us, that or what Mr. Manmeet Singh also said, that people know when they go to a brand that they want this brand. Even if they are shown another ad, they'll not mistake it for the same company, because you know what you want. All of that will have to be discussed or argued before the court of law. But that's it for today. I'd like to thank Advocate Malak Bhatt, founding partner of NM Law Chambers, Manmeet Singh, senior partner with Saraf and Partners, for sharing insights on these judgments. But it's not over yet. We'll take up many more such issues on such lines. But that's for another day. That's it for now. Thank you so much for joining in. Thank you.
Thank you. Thanks, sir.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.